What is mediation? Well, maybe it's easy to start with what isn't mediation, and that's arbitration. A lot of people get the two confused. Both arbitration and mediation are considered alternative dispute resolutions, or ADR, for alternative dispute resolution. And what that means is you're not going to jury trial or you're not going in front of a judge. Typically, when people have a legal dispute and they get in the court system, they end up either going in front of a jury or a judge. So there's alternative dispute resolutions. Arbitration, binding, it's more formal. You present the evidence to the group of arbitrators or an arbitrator, and they make a final decision. You can't appeal it. Mediation, on the other hand, is typically voluntary and it's not binding. That means at the end of the day, both parties can walk away. They don't have to accept what the mediator recommends or suggests, or wherever they end up, nobody has to accept it. They can walk away from it. A mediation will be all the parties involved in the lawsuit. It will then also be a mediator, usually one person who's a neutral third party. It's referred to as the neutral third party, the mediator. And also the attorneys will be present, the attorneys for each of the parties. So how does the mediation begin? What's the process as far as what are people doing? Typically, people will either show up and be in the same room, or they will show up and each group or each party will be in a separate room. The mediator, who will go between the different parties, is usually an attorney, usually an experienced attorney who's been doing this mediation type work for several years. This mediator will eventually have the people separated in different rooms, and he'll go from one group to another group. And he'll carry messages back and forth. He'll carry amounts back and forth. He'll start out with, okay, what do you want to accept? What do you want to demand on the other side to settle your case? He'll usually start with the plaintiff as an example and say, what will you want to settle your case? He'll then get the facts of the case. He usually doesn't know much about the case to begin with, so we have to educate the mediator on our position and our side and our issues. The mediator will go to the other side, say this is what they want, and of course they'll say we're not going to pay that, we want to pay less, and here's what we want to pay and here's why. And they'll present their issues. The mediator goes back and forth amongst the various parties and presents these demands, offers, counter demands, counter offers. Ultimately, the goal of the mediator is to find out how much the insurance company is willing to pay to get the case resolved, from our standpoint, from the plaintiff's standpoint. So when we want to know that, we'd like to know what is the top dollar they're willing to pay to resolve the case. And from the defense perspective, they're wanting to know what is the plaintiff willing to accept to resolve the case. And if those can meet somewhere in the middle, the case will get resolved. And if they don't, they won't. So you really have kind of your day in court in a way, but instead of going to a jury, you're presenting it to the mediator, who's then going back and forth and getting the whole story, if you will, from both sides. And that can be good for multiple reasons. One reason is you don't have the extremes that you might get with a jury. You know, a jury could be a kind of a middle-of-the-road group of people, or a jury could be, you know, really extreme one way or the other. A mediator, in a way, is kind of like your average jury. They've seen it all, so to speak, and they have a good idea of what a jury will likely do. And so because of that, they can tell the plaintiff, hey, if you go to trial, based on what I'm hearing, here's what I think will happen. They can do the same thing with the defense and the insurance company. They can say, you know, if this goes to trial, here's what I think will happen. And most mediators at some point will say, here's what I think a reasonable range for resolution would be. So it's kind of like your day in court, but with a little more certainty, and you can walk away because it's voluntary and it's not binding at the end of the day if you want to. So a mediation can be a good way to try to resolve a case in a lot of cases. Both sides are going to come out of there probably not totally happy, and it's been said that if both parties come out of there not happy, that it's probably been a successful mediation. But you at least know what you're going to end up with. You know what the final settlement's going to be. The problem with the jury trial is oftentimes you have a winner or loser. A lot of times it's a kind of an all or nothing. You may get everything you're hoping for, or you may get zeroed in some of these cases. So the nice thing about a mediation is you know what you've got at the end of the day. So I hope that answers some basic questions about what a mediation is and how mediation works.